Hi, Roy. Hi, Joe. I see Joe on. Joe, I went ahead and allowed you to speak. So if you want to go ahead and introduce Roy and ask questions at the end, you should have that capability now.
Great.
Hi, Joe. I don't see anyone else on yet.
Okay. We can wait a minute if you like, or we're recording it, so I think we'll get a lot of people listening to it that way.
Okay.
Well, to be respectful of your time and anyone's time who may be watching or watching later, let me go ahead and kick us off. So on behalf of the Ventura Fire Foundation, thank you all for joining us, whether you're watching it live or watching a recording at a later date. Before we go any further, I should acknowledge the SoCal fire community had a tremendous loss last night in Riverside when two fire helicopters collided and 3 people were killed, including 2 firefighters. Our prayers go out to their families and colleagues. We thought about delaying or canceling this webinar, but ultimately decided to move ahead because such an important topic that we know many fire families and frankly families in general tend to ignore. And really the events of last night made clear that we shouldn't wait to make plans for our family and property, just in the event that there's a disability or other tragedy. Just a few housekeeping items before we jump in. I'm Joe Booth, the director of Ventura Fire Foundation. We're hosting this presentation as part of our mission to firefighters and their families. I encourage you to check our website, venturafirefoundation.org, or social media pages for other events and information that we put on just for fire families. I want to thank our partner, Schneiders Associates, for presenting today. Schneiders is an amazing partner for firefighters and the Ventura Fire Foundation. Frankly, they make sure we don't screw up too badly. Angela, Cynthia, Jess, and Roy have all been fantastic to work with. I should note that Jess was scheduled to present tonight as well, but is on family leave and not able to join us. The presentation is being recorded and will be posted on YouTube and our website for future viewing. Roy and Jess were recent guests on our podcast, Firehouse Roundtable, talking about many of these same subjects, so I encourage you to go listen to it on Apple Podcasts, Spotify, or wherever you listen to podcasts. If you have any questions, enter them in the chat, and I'll collect them and feed them to Roy to answer at the end of the presentation. If you have a question after the presentation, or you're watching it a week, a month, 6 months from now, and you have a question, don't hesitate to reach out to Roy. He can't cover everything in an hour. I encourage you to schedule a consultation with him. It's free, to get a better understanding of your situation and how he can help. So let me introduce Roy. Attorney Roy Schneider brings more than 40 years of experience to practicing law in the areas of business planning, entity formation, employment law, contract law, estate planning, and nonprofit law. Roy is an experienced estate planning attorney who works with high net worth individuals and charitable organizations in the area of planned giving. Roy strategizes with individuals, couples, families, and businesses to protect their family, their wealth, and their legacy by providing comprehensive estate planning tools that best fit his clients' unique circumstances, from basic to advanced planning techniques such as planned giving, wills, trusts, power of attorney, family partnerships, and life insurance trusts, all of which we'll know a little bit more about after this presentation. Roy frequently speaks before business and nonprofit groups and is also an adjunct professor at Cal Lutheran University teaching business law. That it? I'll turn it back over to Schneiders and Roy.
Okay, well, thank you, Joe, and thank you, anybody who's listening. I appreciate you being here this evening. This will be recorded. If anybody would like a copy of the PowerPoint, just reach out to Joe, or our email address is at the bottom, our website, and you can go there and get a hold of Angela, who's our marketing director, and get a copy of it. So tonight we're going to talk a little bit about estate planning. It is a complex subject and it could take many hours, but we're going to synthesize this to make it relatively understandable. You may have questions and concerns, and we're here to answer you. We are, big fans of the Firefighters Foundation and firefighters of Ventura County. So anyone interested in pursuing estate planning, just let us know. We will send you a questionnaire that you fill out. You come in, you talk about it, tell you what's best for you, and there's no charge for that. And we do provide firefighters with, and anybody in the firefighting family, with a 10% discount from our normal rates. So we do encourage you to come see us, at least to get educated for yourself. We'll begin a little bit now, and hopefully we'll have time for questions, and I'm sure we will. So please send them to Joe in the chat, and we can answer questions. One basic question, of course, what is estate planning? You hear the term, it's discussed, but what is it? Well, estate planning involves a couple of aspects. One is planning for transfer to others. You all have stuff, and you're going to have to transfer at one point to others, either during your lifetime, which is also part of planning. It's also part of estate planning, making gifts, concerned about taxes. That is also part of the plan. At death, and even after death, how are things going to be distributed over years after you pass away? Also, it involves planning for your incapacity. You're in a dangerous profession, but we're all subject to being injured or in accidents, and things could happen. Who's going to take care of us? Who's going to pay our bills? Who's going to run our businesses? Who's going to deal with the taxes and the Social Security and pensions? Somebody has to do that if you're incapacitated. Who's going to make medical decisions for you if you can't? Who's going to handle your financial affairs if you can't? All this is under the rubric of estate planning. And there are tools. There are lots of tools, but this is a few of them. There's wills and there's trusts. We'll talk about different kinds of trusts. Durable powers of attorney, healthcare directives, retirement and pension plans. Firefighters have pension plans and retirement plans. Who's the proper beneficiary? It's amazing how many times we find people have been divorced 1, 2, 3 times, and it's their initial spouse that's still on the plan designation. Another area to consider is family dynamics. And we'll be talking about all of these, but family dynamics is very important. And it is important to review your estate plan from time to time, at least every 3 to 5 years, or if there's major life changes, marriages, births, deaths, grandchildren, whatever happens, winning the lottery, whatever happens, if it's a major life change, you want to kind of pull out your estate plan and give it another thought. Excuse me. Okay, and what is your estate? People sometimes say to me, well, I don't have a large estate. I don't have much. Why do I need to do an estate plan? Why do I need all these things? Well, think about it. What is your estate? Your estate is everything that will pass to others as a result of your death. And it includes things like real estate, obviously, life insurance, retirement, bank accounts. You have a checking account, a savings account. Maybe you have investments, your cars, your boats, RVs, all those that will pass to others. If they're there, if something happens to you, they got to go somewhere. Your household furniture and furnishings, who's going to get the silver and the crystal and the couch and the big screen TV? Where's that going to go? Personal effects. You may have some fishing poles that you like. You may have collectibles. You may have coins that you've collected, stamps, whatever it is. That's part of your estate. It's got to go somewhere. And a business. I know a number of firefighters have side businesses, or their spouses or partners have side businesses. What's going to happen to that business? Where's that going to go? Just disappear? So all those are part of your estate. And if you start itemizing all the things that you have, not just money, the house, all the other stuff, you'll see you have an estate. And if you don't decide where it goes, the state of California will. So we know what an estate is. We know what your estate includes. What is planning? Okay, planning. During your life, you want to plan, as we talked about, for your incapacity. Who's going to operate businesses? Who's going to pay your income taxes? Who's going to collect, disability? Who's going to take care of your investments? Who's going to sell real estate? Who's going to buy real estate? Who's going to buy the insurance on the real estate? Who's going to take care of all these things? That's important. And who's going to provide for your physical needs? Do you need to be in rehab? Do you need to have home care? All this can happen while you're incapacitated. And when you're incapacitated, it could be very short term. It could be 60 days, 90 days, 120 days, or 6 months. Doesn't have to be forever, but during that period, when you don't have capacity because you're on medication or whatever, somebody has to make these decisions because you can't. And also, who's going to make healthcare decisions for you? So that during your life, there's many important things that can happen that you've got to consider. Now, what happens after your death, on your death? Who's to receive your estate? These are very important. A lot of thought should go into these. Who's to receive your estate? Traditionally, it's spouse or partner and kids, but you may not have a spouse or partner or kids. So it could be brothers, sisters, nieces, nephews, could be charities. There's a lot of thought to that. Also, what portion each is to receive? You can't imagine how many times we've seen fights and arguments and families break up over this. Here's a typical situation you might want to think about. Okay, parents have one son, one daughter, Mary and Tom. Mary just never has really been able to stand on her feet, never been very successful. The parents keep giving her money, and over maybe 20 years, they've given her $250,000. Tom, their son, never asked for a penny. He's fine, he gets his own way, never needs anything from them. So the parents decide, well, we might even things up. And we'll give the first $250,000 to Tom because we gave Mary this over time. They both pass away. You will find Mary will be suing Tom. There's a lawsuit will ensue. So it is a lot of thought to decide if you're going to give unequal amounts, even though there's legitimate reason, causes a lot of heartache, a lot of grief, and often a lot of suits. And I'd be glad to talk about that with anybody, because this happens in almost every family. Specific items to specific persons. Maybe you want grandma's ring to go to your granddaughter. Maybe you want your fishing set to go to your son, your coin collection. There might be specific items, and you have to spell that out. And we usually provide a form for that. We don't put it in the trust because people change their minds. But without that, whoever's in charge of your estate, they pass everything out. And they may take the best thing for themselves. So you want to spell that out if that's important to you. The other is outright distribution. Do you want your beneficiaries to get your estate outright? Clearly, anyone under 18 cannot. They have to have a guardian appointed by the court. If they're 18, you can leave them your estate outright. But imagine giving an 18-year-old $1 million or $2 million. That child will be broke at 19. It's just what happens. Doesn't work. It's very unusual. And it's actually not that difficult in Ventura County to have a couple $1 million estate. And it's surprising that may be. So you want to think about when. Maybe hold it to a certain age. Traditionally, we like to spread it out. We might give a third of the estate of that child's when they're 22, get them a chance to get through college, and they will, then give them maybe half the money that's left when they're 26, and they'll probably blow it and spend it, and maybe the balance when they're 30. And maybe by then they will have learned to hang on to it. So, but those are thoughts. Those are not just things they just throw away. We've got to talk about those. Charitable giving. This is a great time to think about charitable giving, such as the Fire Foundation, charities like that, Ventura Fire Foundation, organizations that mean something to you. $10,000, $15,000, $20,000, quite frankly, won't often mean very much to the family that gets the money. But to a charity, that's a lot of money, and it can make a big difference. So if you have a particular charity, religious, educational institution, leave them money. And obviously don't forget the Ventura Fire Foundation. They do wonderful jobs. You may have a child or close relative that has special needs. They receive government benefits, SSI, they get Medicaid. Well, they lose those benefits or they get reduced substantially if they're left a lot of money. So you sometimes have to create what we call a special needs trust. That's there to provide extras for them, trips and clothes and TVs and goodies that they might need, but not their living expenses. And that's something to think about if you have a relative who needs that. Also, since we're living in an age where people are married 2 or 3 times or more, you sometimes want to protect children from a prior marriage. You're married, you've got kids from a prior marriage. So you say, okay, we're going to leave to your kids, and then you're going to leave to my kids. That often doesn't happen. So you want to think about that, because you may have, children from a prior marriage, and your spouse loves those children, but you could pass away, and I'll tell you, 30 years from now, they may not know those children. So it's something to think about, especially when you have multiple marriages with multiple children. The other thing you want to consider with death is to avoid probate. We'll talk about probate. Lengthy, public, costly, time-consuming project. You don't want that. And if you are lucky enough to be wealthy, there are estate taxes. That's just money you give to the government. And there are ways to eliminate and avoid that. Okay, that's a mouthful. If you have no estate plan, you put a burden on your loved ones. They got to deal with all this stuff, and they don't know where to begin. If you're incapacitated and you have no plan, you may need a conservatorship. That's a court-appointed person to take care of your financial and health needs. It's a miserable proceeding. You're interviewed. You may even have to be, brought into court so the judge can see that you are not competent, and you can avoid that with certain planning. And if you do no planning, there's something called intestate succession, intestate. And the state of California has basically written a will for you, and the state of California will determine who gets what, when, and where. If that's not what you want, you need to plan. Plus, you may have to end up going to probate, and a lot of money is wasted in that process. Okay? One of the things while you're alive that you want to consider, part of the estate plan, is the durable power of attorney. It's a special statutory right. It's a special statutory instrument, and it's an exception to the general rule. What does that mean? Generally, if you give somebody a power of attorney, you're going to be traveling through Europe, and you have a good friend, and you're about to close escrow, and you want your friend to sign the documents for you, you might give them a power of attorney. They're very limited. Most power of attorneys, unless they're durable, they will expire on your incapacity, when you become incapacitated. A durable power of attorney, the one we use in estate planning, can take effect now if you'd like, and spouses often do. But if it's other than spouses, and it may be children who can take over for you, you don't want it effective until you become incapacitated. So it's very flexible, but it allows somebody to be your agent and sign and do things for you. Just so you don't kind of jump ahead a bit, once you set up a trust, when you learn about that, your assets will be in a trust. And your bank account, your investments, and a trustee will deal with it. But there are certain things that trust can't deal with, such as taxes, pensions, Social Security, litigation, life insurance. Only the agent under power of attorney can deal with that. Well, that's why they work hand in hand. And the power of attorney, unlike trust, expires on death. So once the principal under the power of attorney passes away, that document no longer is effective. And here's what they do. They power of attorneys basically for the financial, real property, buy, sell, insure. Same with personal property, make investments, sell investments, open, close bank accounts. And also very important for anybody who has a business is to operate that business or sell the business or close the business down or do something, as opposed to having the courts just stepping in. Your agent under the power of attorney can deal with it if it's not in a trust particularly. So these are the kind of the things that they do. Another document, part of the estate plan, is the healthcare directive. You've heard of that. Sometimes they call it a living will. That's usually effective on your incapacity. And it appoints a person to handle your healthcare matters. So it's actually one document that's two things. One is it's a power of attorney for someone to make healthcare decisions for you when you can't. Should we do this operation? Should we not do that operation? Get second opinions, not get second opinions. But even originally, more important than that, is the power of attorney. The agent under the healthcare can talk to your doctors. You may have a spouse or a partner would like to talk to your doctor. Maybe you're exhibiting some weird stuff, who knows? But the doctor won't talk to you, won't talk to your partner or your spouse without a power of attorney. So it's important. Also, and make healthcare instructions. You can put your instructions in personal care. I want to be at home as long as possible. I don't want this or that. End of life decisions is the big one. I don't want to be artificially kept alive if I'm brain dead, kind of thing. You can pull the plug. You give authority for your agent to do those things. Also, interestingly, the agent under the healthcare directive gets to determine the burial, cremation, or other kind of burial. So this is the document where you would put those instructions as well, what you would like to do. Okay, so those are important instruments that go part of the plan. The estate plan is not just a will or trust, it's all these things that we're talking about. So what's a will? A will is a legally binding instrument that will govern distribution on your death, disposition. The person who creates a will is called a testator, and while you're alive, it's generally revocable. You can cancel it, change it, whatever you want. And it actually has no effect until you pass away. The most important part of a will, even when we do this whole estate plan with trusts, wills are very, very important for designating guardians. If you have minor children, the will is used to designate a guardian. Even if you don't have to probate the will, a will document naming the guardian will be a guardian. And so it's useful for that. Wills, disadvantages, of course, is it's cheap to make. You can do it yourself if you kind of knew the rules, but it does not take effect until you're dead. And there's no help while you're incapacitated. There's not much anybody can do. You can get people access to medical records, but that's about it. It's not going to avoid the conservator that we talked about. And also, unless all your assets are going to a surviving spouse, or your non-going spouse assets, the probate assets, does not include real estate with more than $61,500, and your total estate is under 184, does not exceed 184.5, you can avoid probate. I don't know who has property in California worth less than 61.5, unless you were in the big days where people were buying land in Palmdale for the airport that never materialized. But if you have real estate more than 61.5 or other assets outside of a trust, 184.5, you may have to have a probate, and you don't want to do that. Wills can contain a trust, but it's not recommended because you still have to go through the whole will probate process before the trust is set up. Okay, so and probates are expensive. Here's some examples. $2 million estate, you're going to pay $66,000 in fees. $1 million estate, $46,000. Plus, there's additional fees. If the executor, the attorney have to sell real estate, they have to close down a business. That's all extra, all on top of that. Plus, there's filing fees, court costs, and so like that. So it's expensive. The other thing about probate, of course, it's public. So if that's what you have as a will, everyone you know will know exactly what you had and who's getting what. And if you have children that are 19, 20, 21 years old, leaving them a bunch of money, they will be inundated with calls from the Ferrari salesman and yacht salesman, and they may be broke before they get out of the courtroom. So this is the way you want to avoid probate. It's cost money, very expensive. And here's a trust. Yeah, and we'll say how it works, but trust is what you want to do. Let me go back to will for a second. Even with a trust, you're going to want to have something called a pour-over will. What does that mean? You may not put everything in your trust. You may forget. You may go out and buy Colorado property and forget to put it in your trust. You may have a home that you want to refinance. Some banks have come into the 21st century, others haven't, and they will say, you know what, we don't loan money to trust. You have to take it out of the trust, and then we will make the mortgage to you, and then you put it back in the trust. Sometimes people forget to put it back in the trust. So there are situations where you could die with assets more than $184,500, and you're going to have to probate it, but we have a pour over will, and it's called pour over because it says anything that has to be probated, court, just pour it over into my trust. So if everything you have is in the trust properly, that will's never used, except maybe to name the guardian. But if not, and it has to be a probate, it ends up having all the assets go into your trust and the trust will govern. So there is even a will in connection with your estate plan when you do a trust. So trusts are great because they provide for incapacity. If you become incapacitated, you will have a successor trustee. Could be your spouse, could be a partner, could be a child, could be a brother, sister, parent. They will step in and it's seamless. They just step in. They get a letter from a doctor, you're incapacitated. Now they're the trustee. Bank accounts, investment accounts, cars, boats, etc. are in the trust. They just deal with them. And also the trust can control what happens after your death. You want money doled out, as I said before, to your children. They reach certain ages. You want charities to get money. And where is this going to go? The trust can do that. And the family dynamics is the big one. And you have to really think about that. A number of families simply say, my oldest daughter will be the trustee. When talking about trustee, I'm talking about fiduciary person, financial affairs, financial fiduciary. Who's going to handle the money? And siblings get really bent out of shape if one is in charge and the other is not. So it takes a lot of thought. If you have a couple, maybe you name them both as co-trustees. If you have 3 kids, naming them all can be problematic because you often end up with 2 versus 1. Sometimes it's just naming the one who's most savvy. Bottom line is there's something called orphan syndrome. When the last parent dies, no matter how old the kids are, there's orphan syndrome. And they all the kids revert back to adolescence. So your 60-year-old kids act like 15. And they'll say, Mom liked you best. How come Dad liked you? How come they chose you? Mom never liked me. That's just the feelings. It happens. And if you are the brother or the sister that's going to be handling the affairs, if the rest of the siblings don't get all their money in a week, they are convinced you're stealing. So there is a lot of thought and effort that goes into this and a lot of transparency. And if it's a larger estate, if it's a family that isn't extremely close, you're not going to name both kids as trustees. You might want to consider a private fiduciary. There are people out there who are bonded, recognized by the courts. They charge by the hour only once they step in, and they handle it. You know, or a bank, and don't worry about the family fighting because they do. So you've got to know your family, and along with this, there's the question of once you do your estate plan, should you discuss it with your kids and your family? Some parents say, absolutely not. I don't want them to know what I have. I don't want them waiting for me to walk down a dark alley. I'm just not going to tell them. Others say, you know what? If there's going to be issues, I'd like to get it on the table now. And I'm going to explain to my family why Sally's getting the beach house and Tom isn't. That is very personal. And that's something we can all talk about. So we have a whole 1-hour program on family dynamics. It is such a big thing. And that's where the lawsuits come in. So think about it. And don't just name your oldest kid automatically. Avoid probate and also minimize or eliminate the estate taxes. So trust can do that. So here's what a trust is. It actually sounds complicated, but it really isn't. It really is the smoke and mirrors, but it works. And how it works is you, individual that has assets, house, cars, boats, bank accounts, investments, you're called the trustor. And you take all those assets and we transfer them. If it's real estate, we do deeds. Otherwise, we do an assignment, and you go to banks and you change the accounts and you simply transfer to yourself as trustee, just you, a different hat. And your job as trustee is to hold your benefit and pay whatever you want. It's not a separate tax-paying entity. It just takes care of you. It goes on. Nobody has to see it. Nobody gets to say. It's just go on about your life. But then the assets are held for your ultimate beneficiaries. When you pass away, it then goes to the people you've named beneficiaries. Typically, in a family, it would say it goes to my 3 children or their issue. What does that mean? One of your 3 children could pass away before you. Most people say, well, if my son passes away and he has a few kids, his kids should step into his shoes and get his share. And it'll be held in trust until they're, let's say, 25. So that's the normal situation. But that's what it is. You transfer to yourself. Everything has a new name. It's not just you. It's you as trustee of the trust. But you answer to no one. You do, you spend, you buy, you answer to no one. When you die, it goes to the beneficiaries. It's private. Nobody knows. It's handled in the lawyer's office. Everybody gets what they're supposed to get. And there's basically two kinds of trusts. There's more, but there's two kinds. There's the typical revocable family trust. That's what we talk about in estate planning. You can amend it, revoke it, change it whenever you want. Sometimes we provide that if you're a married couple or whatever, you can't amend, the spouse's half or whatever. That's individual. But the revocable family trust is easily to change, easily to amend, do it as life changes, because you don't know. These revocable family trusts have no asset protection, particularly no tax benefits. Then there are irrevocable trusts. They're rare. They're not used that often. They are treated as a completed gift for gift tax purposes, but they can have tax and asset protection. There was a while ago where people were selling these asset protection trusts. Put your house in a trust, put your vacation home in this irrevocable trust, put your business in an irrevocable trust that no one can ever sue and get those. That's not true. You can't take stuff that you use and live on and deal with and say it's not protected because I have an irrevocable trust. It's complicated. But a good example of an irrevocable trust that works well is, let's say you have an estate that's going to be subject to estate tax. And right now it's about $13 million a person. So a husband and wife or a couple would have to have $26 million. Not a lot of people. But assuming you're single and you have $15 million estate, well, $2 million would be subject to estate tax. And the estate tax is 40%. It's a lot. Well, there's something called an irrevocable life insurance trust. It's just a simple planning tool. Where you buy a life insurance policy, it's going to cost you a whole lot less than millions of dollars. You buy a life insurance policy to cover the estate tax. It's an irrevocable trust. On your death, life insurance trust pays the estate tax, and your entire $15 million gets to go to whoever you name. And that's a tried and true irrevocable trust. All the other kinds of crazy irrevocable trusts the IRS doesn't like, and they're always attacking them. But we can talk about that. Okay, so other benefits of a trust. Again, we talked about protecting children from prior marriages. Suppose you're married and you've got $5 million and you've got a kid from a prior marriage and your spouse has a kid from a prior marriage. You got $5 million that you own together. You can say, on my death, I'm going to take my $2.5 million and put it in a special trust, where my wife or husband gets all the income, principal if he or she needs it for health, education, support. But on my spouse's death, I know my kids are going to get what's left of this special subtrust. That's one way to protect children from prior marriage. And there is some possible asset protection. One, this trust I just told you about for your children, it is not subject to the claims of creditors. Your spouse's creditors, your kids' creditors cannot get to it. Or you're married and you don't have the kids issue. You have a lot of money, but you're concerned that your spouse is going to give away all the money to the next Benbow or Gigolo that comes along. Well, you can protect that as well by saying, okay, we've got X millions of dollars. I'm going to make sure my half is in a special trust on my death. And the spouse can use the money, income, needs it, but it's protected from creditors and they can't just give it away. So those are all things that, that maybe you've never thought about, the things that you can think about. Plus the estate tax savings. If I told you that right now husband and wife can have $26 million as spouses before there's an estate tax. Well, you might have, if you just pass away and leave everything to your spouse, she could very well, or he could exceed the $26 million. Or let me go back, excuse me. $13 million a person, 13 million. So you pass away and just leave your 13 million to your spouse. Now your spouse has $26 million, a single person, 13 million will be taxed at 40%. If you say, gee, we got $26 million between us. When I die, I'm going to put 13 million in a special estate tax savings trust. So now, when your spouse passes away, you got your 13 million in a special tax savings trust. He or she gets 13 million that it can pass on to others without tax. You now can pass 26 million without tax. There's a way of doing that. And there's other ways of doing it too. We have something now called portability. You don't have to actually set up these separate trusts. You can file things with the government so that your spouse gets the benefit of your $13 million. A little complicated, but something to remember that the special planning, you can actually double the amount of the estate tax savings that you'd otherwise have. I hope that's clear. Okay, and you avoid the probate. There's something called probate avoidance trust, and that's 99% of the trust that people get because most people don't have $13 million. And they're worried about estate tax for couples with 26 million. So a trust avoids the probate costs, doesn't have any tax planning provisions, but you can protect children from prior marriages and protect some assets. Is joint tenancy a good idea? I've had people come say, you know what, I got a house, I got a vacation home, I got a couple of kids. I think I'll just set up joint tenancy and I won't have to probate, won't be trust. Joint tenancies are easy. Well, okay, let's talk about some of the advantages of joint tenancy. It does avoid probate because it automatically transfers to the survivor on death. It's not part of the probate estate. It just passes on to the survivor. And it will avoid creditors of the deceased joint tenant. So if you're in joint tenant with somebody and they owe a lot of money and they pass away, that property is not subject to the creditor's claims. It's easy, inexpensive, and almost any kind of asset can be joint tenancy. Real estate, bank accounts, securities, cars, boats, whatever. It's easy. Married couples should never hold property in joint tenancy. It's best to, real estate for sure. It's better off holding it as community property or investments. We have something now, and it's fairly recent, community property with right of survivorship. It's treated like joint tenancy. There's no probate. It's relatively easy to clear up when somebody passes away. But the advantage is there's only about a dozen states that are community property states. And on the death of one spouse in a community property state, you get what's called a 100% step up in basis. So let's say you bought a rental property for $500,000 a few years ago, and now it's worth $2 million. If it's held as community property with right of survivorship and one spouse passes away, the IRS and the state of California, Franchise Tax Board, consider you paid $2 million for that property, which means if you sell it for $2 million, there's no capital gains, no income tax. Otherwise, if you have a property that went up $1.5 million, you'd sell it, you'd have capital gains. If it's joint tenancy, you do not get 100% stepped up in basis. Only half would be. So you don't want to hold property as joint tenancy that has increases in value. Okay, so if your spouse is your joint tenant, I mentioned that you get 100% step up in basis. Joint tenancy, only half gets stepped up in basis, and the property sold, it'll be capital gains. This is for, there's different rules for your house. We'll talk about that too. House, with regard to your home, you get if you're married and you sell your house, you get a $500,000 a gain exclusion. But if somebody passes away, this community property and joint tenancy stuff makes a big difference. And if you put it in a trust, it retains its character. So let's say many, realtors sometimes just check off the boxes, and you buy a house and they just check off the boxes, say joint tenancy. If you came to us, we would then transfer the property from joint tenancy to you and your spouse as community property, and then from the community property to the trust, because the property, retains its character as community property when it's in the trust. One spouse passes away, you could then sell the property capital gains free. Okay, disadvantages, okay. One, joint tenancy isn't compatible with estate planning. If you have joint tenancy with your spouse, but you don't have a trust or anything, you have no say where it goes on your death. It just goes to your spouse. Maybe you want it to go to the children or something like that. And also it could cause that spouse's estate to increase for estate tax purposes. Okay, so if someone is other than your spouse, well, you see this too, with brothers and sisters or friends, they decide they'll take property in joint tenancy. Again, you can't control disposition. You know, you may have property with your brother or sister and a kind of an understanding that if one of you passes away, their children will get that half. They may not. There's no way to enforce that. You can't control disposition. As soon as someone passes away, the survivor just gets all the property. If you create a joint tenancy, it's a taxable gift. You decide you're going to put your kid on your apartment building, that's a taxable gift. File a gift tax return. The other problem is putting children on joint is a terrible idea. Put your children on title as joint tenancy with you. You may have the best children on earth. They may be honest, good, decent people, but you have no way of assuring yourself that your daughter may not take out a school bus one day and get a $10 million judgment against her. If she does, you lose your house. That property is subject to the creditors while they are alive. And also they can transfer it. They can transfer their interest to somebody you don't like. So putting children and other people on as joint tenancy is often not a good idea. Sure, for some bank accounts, older parents, they need to pay groceries and a few things, sure, put the son or daughter on that account. But big assets, especially investments accounts and homes, no. If you do not want to have an estate plan, and you basically just have money, you just have basically investments, you can also set up what's called a payable on death account. Let's say you've got a $500,000 CD, and that's the extent of your estate. You can put it in trust, which is a good idea. You can put a joint tenant on that account, not a good idea. Or you can create a payable on death account. Bank has a form, you just go to the bank, and upon your death, that named beneficiary comes to the bank with a death certificate, and they'll get the money. Okay. Again, joint tenancy, if you have someone certainly other than a spouse, you've given them the keys to the vault. The money's there, they can take it out, they can do whatever they want, the creditors can take it. Not a great thing. Let's talk now a little bit about Proposition 19. It's already a little old. It's a couple years old, but not everybody understands it. And it's important to mention. Okay, one, it allows now, you can transfer real estate if you're 55 years and older to all counties in California. It used to just be within one county or with counties that had special rules. Now, any county in California, and you can transfer up to 3 transfers in your lifetime. The advantage is, you bought a house 40 years ago, very low tax basis. You want to buy another house. You don't want the tax basis going up to the present value of that new house. You'll keep your old tax basis to the extent that the house is not cost more, not more valuable. And you can do it up to 3 times. Most older people, they downsize. But if you bought something for $200,000 and now worth $1 million, you're paying your property tax on it $200,000. But if you sell it and buy something for $800,000 because you're downsizing, well, without this rule, you'd be paying $8,000 in property taxes. So this allows you to transfer that $200,000 low basis up to 3 times, which is cool. If the house is $1,200,000, then you will pay on the $200,000. You'll pay on the excess of the value property tax, and the additional value will be assessed on top of the value transferred. So if you transfer your $1 million house and you buy 1.2, you'll keep your $200,000 property tax basis plus tax on $200,000 more. Hope you understand that. Here's the bad stuff that's interesting. Used to be, before February of 2021, if a parent owned a house that that parent lived in, he or she could pass it on to their children, and their children could keep the same property tax base. And again, bought a house for $200,000, now for $2 million. They got the property, the kids, they can keep the $200,000, the $200,000 tax base. Now, if it's a primary resident of the parent, and the parent transfers it to a child, and the child is going to use that as his or her primary resident, then they get to carry over the tax basis plus $1 million. So let's say there's a $2 million home today that has a tax assessment of $500,000. So the parent is paying tax on $500,000 assessed value. Child's going to live in the home. And for the first $1.5 million is taxed at the same rate that the parent had. The parent's tax basis plus $1 million. Anything over that would be taxed at that fair value. It can kind of make sense. Okay. That's it. Yeah. So if it's $2 million, that means you're going to pay $1.5 million, be the same, and the other $500,000 is going to be taxed. So basically, tax double. And the reason for this was really pushed by the realtors, because there were, kids inheriting property that their parents bought in Malibu, 50 years ago. Now they're getting, $30,000 a month rent, and the property taxes were low, what they were 30 years ago. Now they can't. The property tax will become $30 million. Point being, if you inherit property that if it's not your parents' principal residence, and it's not going to be your principal residence, it's just taxed at its current fair market value, which is substantial. And property tax go up 10 or 20 times what the parents were paying. And it was to help, sell properties. No reason for people to inherit property their parents bought in the 70s, early 80s for $500,000. Now it's worth $20 million, and they're making huge rents, and they're paying pennies on property tax. So that's a big one, property tax. And you got to think about that. And there's issues then if there's 4 kids who have left the property, only one's going to live in there, maybe only 3/4 of it will be reassessed. So a lot of issues, a lot of things to talk about. I know we've covered a bunch of stuff, and I hope I didn't make it too confusing. You can certainly get this PowerPoint. So maybe you've got some questions. Does anybody have questions? We've got some time here, and we can answer some questions.
Hi, Roy. This is Joe. First, thank you. I've gone through the process of having our estate plan done, and I listened to you on our podcast. Now I've listened to this, and bottom line for me, I just need to hire you to tell me what to do because it's so confusing. But we did have some people send me some questions beforehand. This first one is a little bit self-serving, but I'll throw it out there. Many people include gifts to charities in their estate plans. You talked about that. What are the advantages to doing that? And should you tell the charity that you've done it, or just wait to let them find out once you pass on?
That's a great question. And there are a number of ways you can benefit charities. There used to be tremendous tax savings when the estate tax exemption amount was low. Actually, it used to be $600,000, and everything $600,000 you had was taxed. Now it's $13 million. But assuming you've got a $14-15 million estate, and there's going to be an estate tax, well, you have a choice. You can give the money to Uncle Sam, or you can give it to a charity. Charity is deducted from your estate, so there's no estate tax. So that's one very good tax reason for it. The other is to have real philanthropic purpose, to help benefit something you care about. Whether you should tell the charity, it's kind of up to you. You don't have to. You can. You can always change your mind, and charities have to understand that. Some charities actually have programs where they say, if you leave us, if you're telling us you're going to leave money in your estate to us, we're going to put you on a special board. And that might encourage you not to change your mind. So it's up to you. You can tell the charity, I've left you a gift in my estate. You don't have to tell them the amount. There are some very interesting estate planning tools for charities. I'll just throw one out that's great. Let's say you're older and you've got a rental property and you're tired of being a landlord. But if you sell it, it's going to be a huge income tax problem. And you're tired of repairing it. You don't want to hire people. You don't want to live on the roof anymore. You don't want to worry about tenants. You could take that real estate and put it into what we call a charitable remainder trust. Let's say it's worth $600,000. You put it in a special irrevocable trust, and you will get a $600,000 charitable tax deduction. which may eliminate income taxes for a number of years for you, then that property is sold for $600,000 tax-free because it's owned by a charitable trust. And you can get income from that, 10%, 12%, 15%. There's actuarial tables and certain formulas, but you can get income from that for your life. And on your death, whatever's left goes to a charity. The disadvantage, of course, it's out of your estate and your kids won't get it. But the advantage is big tax deduction, nice income, and you help a charity, and it's painless. And if you're young enough, actually people have taken the money from that they get for the charitable reduction, and they buy life insurance so that their kids will get the same value in life insurance. There are ways to benefit charities. So I gave you more of an answer than you needed, but it's a great question and it's worth discussing.
Oh, yeah, for sure. Thank you. Another question. So firefighters are leaving the fire service before retirement, like due to disability or PTSD, something like that. That's on the rise. So in terms of estate planning, how should firefighting families consider that in their estate plan, that at some point in the future, that may happen for them?
Well, you do not want to count on it. You don't want to assume that's going to be in your income. Is that, what you can consider, of course, is on these benefits, if there's going to be a death benefit, well, who's going to get that? And naming those beneficiaries is important. Is your spouse going to continue getting these benefits after you pass away? It's really hard to say how you calculate it because it's so speculative and hopefully never be used. But it's a dangerous profession, and you should, consider it and kind of add it as a contingency. But it's nothing I would really count on. But beneficiaries are important. The name.
Sure. You hinted on this earlier as well, but as you know, many firefighters, they might own multiple properties, have kids, maybe have a side business, and I think that that's fairly common for a lot of the firefighters in Ventura. For them, how complicated is it to put together an estate plan? Obviously they don't want to go to whatever LegalZoom because it's way more complicated than that. But what in terms of their time and their effort, what are we talking about?
Okay, let's assume a couple of rental properties and a business. Okay, so one, you would transfer your business to the trust. If it's a corporation, your trust would be the shareholder. If it's an LLC, your trust would be the sole member. If it's a sole proprietorship, you transfer the assets to your trust, and your trust is the sole proprietor. Relatively simple to transfer a business. If you have a number of partners, that adds a little complexity to it because you've got to get consent and you buy-sell agreements and so on. But transferring the business is relatively simple. Properties, it's really individual. You do not want to own the properties in your own name because they got to be probated. We often recommend setting up limited liability companies. If you've got one or two rentals, they can all be owned by one limited liability company. And the owner of that LLC, the member, would be the trust. There is asset protection. The asset protection works if somebody gets injured on their property and they can't go after anything else. If you've got large number of properties, sometimes people have several LLCs. If you've got one rental house, quite frankly, insurance may be all you really need. And that one thing about insurance, nobody likes insurance. As we all know, when you call up an insurance company and make a claim, the first words they say is no. But you want to get as much insurance as you can afford, and you all want to have umbrella policies. And if you own one house, the risk is slipping and falling. Insurance might cover it. A little more peace of mind, put it in LLC. If you own an apartment building where there's a living manager, where there's risks that are not insurable, such as the manager assaulting someone, then you definitely want an LLC. And then you just transfer the LLC to the trust, or the trust sets up the LLC. They're not all that complicated.
Okay. I think this question gets to the joint tenancy issue that you were just talking about, but let's see. A family friend recently added their children as co-owners of their home. they said that doing that will result in a lower tax liability on the property when the parents pass.
Well, okay.
Well, my own attorney said that that's a horrible idea. So they've heard from two different people that it's good, that it's bad. What do you think about that situation?
Well, when you talk about tax liability, I'm not sure what tax they're talking about. Property tax, if the house goes way up in value, yes, it's only going to be reassessed on the half they don't own. But here's the thing. Okay, they made a gift to the kids. This is the gift of the house. That's the kid's basis in the house. If the house goes up in value later and it's sold, they're going to pay capital gains on the basis of their half that they own. It is tax-wise much better to inherit property because then they would get 100% step up on death. So the house, the parents bought the house for $1 million, kids now have a $500,000, but the house goes up to $3 million. They want to sell it. Their basis on their half is still $500,000. They're going to pay capital gains. If they inherit the house after the last parent dies, now the IRS treats it as if the kids paid $3 million for it, and they can sell it tax-free. So it's not a good idea to put them on. Plus, again, as I said, one of those kids takes out a school bus and gets a $10 million judgment against them, the house is gone. So there is no tax benefit really putting the kids on as joint tenants. It's a bad idea. You're better off inheriting property than being joint tenants.
Got it. And I think this is the last one that I got. This goes towards the family dynamics issue, which I know you said you have a whole presentation just on that. But if you change your executor, your trustee, or who's going to be the guardians of your children, should you tell the old people, the people you took off, or just let them find out after you die?
Well, it's tricky. The guardians, I would always tell, because you don't want to surprise somebody with, guess what? Now you got a few kids. So you always want to discuss it with the guardians, get their permission, make sure they're on board. If you have told the old people that they're the trustees, makes sense to tell them they're not, so they don't get all carried away if you pass away. But if you haven't told your successors, you're going to be a trustee when I die, you don't have to tell them if you changed them. But it is a good idea, I think, to talk to the people who you are going to name as successor trustees. So again, they're not surprised, because they could say no. You know, you pass away and you name Sam as your successor trustee, and Sam says, I want nothing to do with this. Now it's a mess. So I do recommend you let them know. And then if you take them off, you certainly can tell them, I've now changed my mind. Don't have to, but you want to make things as smooth and easy as possible.
That makes a lot of sense. And that is, I think, all the questions that we have gotten. Again, if anyone is watching, later and has questions, please, Roy's contact information is here on the screen. They're fantastic to work with. I can't recommend them enough. And Roy, thank you so much for doing this and taking time out of your evening to talk to some firefighters. We really appreciate it.
My pleasure, Joe. Always willing to help, and I appreciate this opportunity. And anybody has a question, just please contact us and we will answer them.
All right. Thanks so much.
Okay, bye-bye. Have a good evening.